Good morning, everyone. It's nice to see that we have such a great group of folks joining us here today to learn all about the Ontario Not-for-Profit Corporations Act 101. And we have our workshop led today by Benjamin Miller of CLEO. And before starting this meeting, I would like to acknowledge the long history of Turtle Island from coast to coast and the original people of this territory. Since the beginning, there have been Indigenous people who have been stewards of this place, the traditional territory of the Haudenosaunee Nations, Anishinaabe Nations, and neutral people who have taken care of this land, where today is the place of Huron and Perth counties, which are covered by the Huron Tract, Treaty 29, and the formed in 1827, and by the Saugeen Tract, which is Treaty 45 and a half in 1836. I'm grateful for the generations of people who have taken care of this land for thousands of years before us. And I recognize the inequities connected to colonization, and I raise awareness to ensure this history never repeats itself, and to raise awareness of the need to continue to learn about our history as colonizers. I show respect, recognition, and commitment to the ancestors of this land to move forward in the spirit of reconciliation, actions, and initiatives to aid the present and future generations of Indigenous people, and to create an inclusive and vibrant community for all. At the United Way, as part of the Truth and Reconciliation Commission's call to action number 92, we adopt the United Nations Declaration on the Rights of Indigenous Peoples, and we see it as a reconciliation framework and apply its principles, norms, and standards to corporate policy in core operational activities involving Indigenous people and their lands and resources. At United Way, we commit to working together to implement the declaration based on lasting reconciliation, healing, and cooperative relations. And I would like anybody to introduce themselves in the chat box if they feel comfortable. We're such a large group, so going through and doing personal introductions doesn't really allow for that. But if you'd like to use the chat box, and also if you would like to, you can also share a resource, personal reflection, or learning with regards to Indigenous reconciliation to share with the group if you would like. And just a little reminder, we are recording this session to share with others that are unable to attend today. And I would like to thank Community Legal Education Ontario, so that's CLEO, for providing their services through the Nonprofit Law Ontario Association project. And a particularly special thank you to Libro Credit Union. They are the ongoing sponsor of the United Way's workshops for the nonprofit and charitable sector. And today we are joined by Marty Rops, who is the regional manager for Huron Perth at Libro. And Marty would like to say a few words to us. Thanks, Marty.
Yeah, great. Thanks, Krista. Hello, everyone. Yeah, great to see such a large turnout for this topic. I know I know very little about the ONCA, but I know there's been a number of changes over the years that have certainly generated a lot of questions from people. So I think a very timely topic to bring to the group. I just want to speak a little bit about Libro for those who don't know us. Libro is we are a full-service financial institution, and we are the largest credit union in Southwestern Ontario. So as a credit union, we are a financial co-op. We have over 110,000 owners. We call our customers owners because as a co-op, everybody who deals with us is a part owner of Libro, and we do have assets of now just of around $6 billion. Within the Huron-Perth region, we have over 23,000 owners, and that includes personal accounts as well as business accounts, organizations, and not-for-profits. In addition to providing all the financial services anyone might need, we're also a certified B Corp, and B Corps are businesses that measure purpose beyond profit. And we show this, I think, within Libro in a lot of different ways. We show this by our democratic structure. We show this with the positive culture that we build for our staff and for our owners. It's also around our focus on growing prosperity in Southwestern Ontario and our focus on the environment, management and socially responsible investing products. And at the end of the day, whatever we do, we always keep our owners at the center of everything that we do, and know that there should never be a conflict between what is best for Libro and what is best for our owners. We also understand that through our products and services, through our operations, our business practices, partnerships and collaborations, these are all ways that we can positively impact our communities and also help address some of the more challenging issues that we face in our region. So within Libro, we've actually identified 4 pillars, which are key areas of focus that we deliver our promise to grow prosperity in our region. And those 4 areas are, I'll just list them here. One is around employment. And again, we all know the severe labor shortage that we've been experiencing here for the last couple of years. So how can we at Libro help to contribute to that? I'm also proud to say that Libro is a living wage employer and was one of the first organizations in Huron, Perth to step forward with that. Our second pillar is around local food accessibility. You know, we live in one of the richest agricultural areas in Canada, and we still have so many examples, too many examples of people that are not able to access fresh, healthy food. So how can we look for ways to try and bridge that gap? Our third pillar is around housing. And I don't think I have to share with anyone here that the challenges we're having around that, the housing shortage, as well as the challenge it is for people to purchase their own home, to find a rental property. You know, we're looking for ways that we can be a part of those discussions and part of those solutions. And the last one is around financial resilience. And this is around our overall coaching and our focus on one-on-one interactions with people around basic budgeting, money management, but how can we help people to feel more comfortable with their own financial situation? So those are the 4 key areas that we focus on. We have many examples and success stories along the way that connect with all 4 of those. And again, we're always open to more discussions with different groups. So we've been a long-term sponsor of this event series. Very happy and proud to do so, but always looking for impact from participants on what are the topics that really interest you. So I know I think there will be a survey going into the chat. Actually, it's popped up here right now. So I encourage everyone to take a few minutes, fill that in, as well as you know, please suggest any other topics that may not be included there. Again, these seminar series, the topics are for you and for your benefit, and the more feedback we can get, the better it'll be for everybody. So thank you for this opportunity, and Will, I'm going to pass it on to you.
Thank you, Marty, and thanks to everyone for voting in the poll. And if anyone has specific ideas for workshops that would be helpful to your organizations, please reach out to us at United Way Perth-Huron. And I wanted to mention that we're creating a ONCA resource page as well for our website, which is going to include this recording, another recording from another event we did, as well as CLEO resources and so on. Finally, I wanted to mention that I'm going to be posting a feedback form in the chat at the end of the workshop and circulating that afterwards. So if you wouldn't mind filling that out to help us improve our events, that would be terrific. Thank you. And I'll pass it back to you, Kristen, to introduce Benjamin.
Excellent. Thanks, Will. And yeah, we're always open to topics that you would like to learn about. So as Will said, please contact us, and I will put in the chat box email addresses for you to reach out to us. And as Will said, I'd like to introduce our facilitator today, who is Benjamin Miller. He is a staff lawyer. He's just given us a little wave. A staff lawyer from the Community Legal Education Ontario, CLEO, where he focuses on the legal needs of nonprofits and charities. Over the last 5 years at CLEO, Benjamin has answered hundreds of nonprofit law questions and developed an online interactive bylaw builder for the ONCA. So we do have an expert amongst us, so that is great. Benjamin also works at the Ontario Nonprofit Network and has worked at Canada Revenue Agency in the past. He holds a JD and MPP from the University of Toronto and an MA in political theory from the University of Ottawa. It gives me great pleasure to hand over the presentation to Ben Miller, and thank you for joining us today.
Thank you for having me. I'm heartened to see such a large and excited crowd. Hopefully, I will live up to your expectations this morning. Okay, so we're here to talk about Ontario's Not-for-Profit Corporations Act, or ONCA for short. We'll talk about what's new in this new law. So it came into effect on October 19th, 2021, and it replaced Ontario's Corporations Act. So we'll talk about some of the bigger differences. Then we'll talk about the steps nonprofits may need or want to take to bring themselves into compliance with the new law. And then finally, I'll highlight some of the resources that are available on our website, all free to help you with the transition process. I will flag right now that this presentation is the product of many questions from many past workshops. Your questions are enormously valuable, not only to me, but to all future participants in this workshop. So I really do encourage you to ask questions. The way I'll be taking questions is there will be a stopping period after each of these three sections. And I'll take questions at that point, either in the chat or if you'd like to raise your hand. We can have Will or Kristen or someone monitoring the chat and keeping track of questions. Okay. So you heard I'm from Community Legal Education Ontario. We're a legal clinic, part of Ontario's legal aid system, and we have free plain language legal information on a wide range of topics. I'm just a small corner of CLEO. So either your organizations, or the people you serve might be dealing with legal issues such as employment law, criminal law, family law, immigration law, housing law, human rights law, you name it. We have free legal information on it. So I would encourage you to check out some of our other websites like stepstojustice.ca, and it's available in English and in French. All right, as I am a lawyer, I do so love disclaimers. I have not one, but 4 disclaimers for you today about what this presentation is and what it is not. So firstly, it's general legal information. It is not tailored legal advice. That's not because I don't want to help you or give you a straight answer. It's because I can't. Without reviewing your documents or knowing your organization's history, I can only provide general information that I hope will be useful to you. Secondly, this is a high-level overview of the ONCA. It's not comprehensive. I'll show you our website where you can learn a lot more detail about everything we'll talk about today. And it's not meant to deal with other areas of law that might affect you. So let's say you are a daycare, let's say you're a hospice or a healthcare provider of some other kind. There will be other laws that affect you. Let's say you're a charity. There's charity law to think of. I'll be flagging in a few places where things may be a bit different for charities, but by and large, I'm just talking about the ONCA and not how those other laws may affect you. Thirdly, this presentation is about law. It's not about best practices. My job here today is to highlight for you some of the options that are now available to you under the law, but just because something is legal doesn't make it a good idea. It's for every organization to decide for itself what makes sense for it. And then finally, fourthly, this is about law. It's not about your funders' expectations. When we come to talk about the financial review standards under ONCA, we'll be talking about the minimum requirements according to ONCA. Funders can expect more, and in fact, they often do when it comes to when you need to have an audit. So they may be aware of new flexibility under the ONCA, they may not be aware. So that's a conversation you may want to have with your funders. The purpose of today is just to highlight what those minimum requirements are under the law. So to ensure we're all on the same page in our conversation today, I'm going to explain a few key terms. Some of you in the pre-survey signaled that you have, knowledge level 3, 4 out of 5 on ONCA, in which case this will just be a refresher, but many of you signaled a 1 or a 2, and so this is a good place to start. All right, so ONCA, Ontario's Not-for-Profit Corporations Act, as I mentioned, it took effect on October 19th, 2021. It is a piece of corporate law, which means it deals with things like your organization's governance and its record keeping. So Who's the board? How large is the board? Who are your members? When do you have members meetings? Where are you supposed to keep your records? It deals with things like that. And we'll be talking more about that today. Governing documents. We'll be talking a lot about governing documents today. I'm going to explain 3 types of governing documents, but today we're only going to be talking about the first 2. So number 1, letters patent. Letters patent is the document that the government first sent you when you became incorporated. It will have important information like your purposes, your name, your founding directors, your headquarters. Now, under ONCA, it's referred to as your articles. Okay, so there's been no change in the document as such. It's just a new name for the same document. So when you go looking for the document, you're not looking for a document that's titled articles. You're looking for a document called letters patent. But when I talk about articles under ONCA, I'm talking about that document. Number 2, your bylaws. You may call them your constitution, your rules of governance, your governing rules. You may have any number of names for them. The key thing is that this is a document your organization created, and it contains your rules of governance. So how votes are conducted, how elections are conducted, what officer positions you have, a whole range of different governance questions would be answered in this governing document. Again, a rose by any other name would smell as sweet. It could be called a constitution. It could be called something else. What we care about is it that document that you created that contains your rules of governance? And then finally, there are policies. You may have various kinds of policies, codes of conduct, confidentiality policies, member handbooks, HR policies, and so on. Policies tend to be more detailed and more operational than bylaws or articles. And ONCA doesn't have much, if anything, to say about policies directly. So today we'll be talking about articles and bylaws. We will not be talking directly about policies. I would also note that later on in the presentation, I'll discuss how we actually approve changes to bylaws and letters patent. And I would note that policies are pretty much completely flexible in terms of how you approve and change them. It's entirely up to your own organization's approval process that you decided for how to change policies. So changes to policies do not follow the same rules as changes to letters patent and bylaws, which we will discuss later. So some key people in your organization, or better said, some key roles in your organization, because they can be the same people. So number 1, members. Members are to nonprofits as shareholders are to for-profits. Ultimately, the nonprofit answers to the members. It is the members who are responsible to elect the board and have the power to remove the directors from the board. The approval of members is required to change the bylaws and other governing documents and make other major decisions, such as changing the name, mergers and acquisitions, sales of major assets, etc. So the members are super important. I often get the question, do we need to have members? And the answer is, unless you are a very obscure type of corporation with a very old act that's entirely its own rules, the answer is yes. 99.9% of all nonprofits in Ontario have members. So you may say, well, we don't know who our members are, or we don't have members. Well, if that's the case, firstly, don't worry. It's a common situation. I get asked the question a lot. The first place to look to figure out who your members are is your governing documents. In particular, typically bylaws will include some kind of section defining who is a member, and figuring out who qualifies under that definition would typically be the first step to figuring out who the members are. Let's say the governing documents don't define who the members are. Well, if looking back through the history of governing documents to see if there ever was a time when the governing documents included a definition might be a second step to figuring out who the members are. If all else fails and membership is never defined, then by default under ONCA, the members are the founding directors and anyone appointed as a member by the board. If after all that time, the people who meet that definition have passed away, or you can't find them, at that point, it may be time to seek some legal advice. So secondly, directors. So directors are responsible for overseeing the management of a nonprofit, or in the case where there are no employees, themselves managing the nonprofit. Ultimately, as I mentioned, the directors, also known as the board, also known as members of the board, the directors answer to the members. The directors exercise their powers collectively as a board through board resolutions. This is in contrast to officers. Officers, for example, president, secretary, treasurer, etc. Officers who are by default appointed by the board. So the directors are elected by the members. The officers by default are appointed by the board. Okay. The officers have individual jobs. And they have individual powers to execute those jobs. So the treasurer might have individual powers to review and access financial documents or signing authority and so on. They need those powers in order to do their job as treasurer. Okay, this is in contrast to the board, where members of the board do not have individual powers, they have collective power, collective authority to do various things. Now I get the question, our only members are our board. Is that allowed? Yes, absolutely, it's allowed. This structure is often referred to as a self-perpetuating board. And the key thing to keep in mind, if you have a structure where a single individual is wearing multiple hats, let's say they're both a member and a director, or they're both an officer and a director, or they're a member, director, and officer. It's all one person, right? The key thing to keep in mind is it needs to be clear when they're acting in what capacity. So for example, it's common to have a members meeting and a board meeting side by side. That's fine, that's perfectly allowed. The minutes documenting these meetings need to make clear, now we're having a board meeting and we're making such and such decision as a board. Now we're having a members meeting and we're making such and such decision as members, because the powers and the authority and the procedures are different. Okay, so I will pause here because I see there's some notes in the chat. Okay, people just saying hi. Hello, everyone. Good morning. So why care about the ONCA? Here are 4 reasons to care about the ONCA and 2 reasons that you don't need to worry about the ONCA. I note that many of you who filled out the pre-session survey said you were excited to look at your governance. And I think this is a great emotional place from which to engage with the ONCA. There are minimums that the ONCA requires, but beyond that, if you're an organization that hasn't looked at your governing documents in a long time, this is a great occasion for you to pull them out, blow off the dust, and ask yourself the question, do these rules still make sense for us? Is our governance helping to make us more effective as an organization, or is it just so much red tape or rules that are outdated that we just ignore, and therefore they don't add much value? So that's number 1, you might want to care about the ONCA as an opportunity to revisit your governance and ask yourself important questions. Number 2, some new things are possible under the ONCA. Not everyone who was required to get an audit before is now required to get an audit. So that may be a monetary difference for you. If you were getting an audit every year and you didn't feel you needed to, you may now qualify to not get an audit. Number 3, your funders may ask you, have you complied with the ONCA? For them, it might be an indicator that you have your act together, that you're on top of your administrative duties. So this could be a way to signal that you do in fact have your act together. And then finally, number 4, to avoid confusion later on. So I mentioned ONCA took effect on October 19th, 2021. Now, currently we're in a transition period that lasts until October 18th, 2024. At the end of this transition period, ONCA says that a nonprofit's rules that are not compliant with ONCA will automatically be considered to transition over to ONCA compliant rules. Now, that doesn't mean your documents are going to magically be edited. What it means is that the rules contained in your documents won't reflect what your rules necessarily are. That's a confusing situation that I'm sure is going to happen to at least a few nonprofits. To avoid that confusing situation, all nonprofits need to do is bring their rules into compliance before that October 19th, 2024 deadline, right? Do it by October 18th, 2024. And I'll talk later about a few exceptions to this where there isn't even a 3-year deadline. Okay, so now here are 2 reasons nonprofits do not need to be worried about the ONCA. As I like to say, there are many better reasons to lose sleep these days. Number 1, there are no ONCA police. It is nobody's job in the government to come knock on your door and ask you, have you complied with your bylaws? So you may ask, well, if no one's looking, why should we care at all? Well, the way ONCA is set up is your directors, your officers, your members, in some cases your lenders, have powers to, if they believe the nonprofit is not complying with ONCA, to take the organization to court. This happens very rarely, and the reason it happens very rarely is, first of all, because individuals that are involved in the nonprofit, whether director, member, officer, typically they want the organization to succeed, right? And nothing hurts an organization like litigation. It's bad for the reputation, it's emotionally draining, it's expensive, it's time-consuming, it's distracting, etc. Right? So in most cases, even when there is a compliance issue, people find a way to work it out without necessarily resorting to litigation. The second reason is that even if an individual doesn't want the organization to succeed, you need to be particularly motivated in order to undertake litigation, because it's an expense to you personally, it's time consuming, again, it's draining, etc. Right? So it's very rare that things result in litigation. So what that means is that engaging with ONCA, because it's an opportunity to improve the organization's governance and make the organization more effective, is a much more practical and realistic reason for engaging in ONCA than because of some fear of consequences or penalties and so on. I would note that things are slightly different for registered charities, and I'll point out those slight differences down the line. CRA is responsible for ensuring various kinds of compliance, so I'll note what that means practically later in the presentation. The second reason that nonprofits do not need to worry about the ONCA is that it's not a major overhaul. So if you're familiar with Ontario's Corporations Act, the previous act, right, by and large, you're going to be familiar with ONCA. This is not going to turn any organization upside down. So for all those reasons, you may want to care about the ONCA. Okay, so what's new? What are some of the newest elements of the ONCA? So probably the newest element of the ONCA is this idea of a public benefit corporation. Previously, under Ontario's Corporations Act, all nonprofits faced a level playing field. Okay, there were slight differences for charities, but by and large, same rules for everybody. Under ONCA, by default, everybody faces a level playing field, but then some nonprofits face some additional rules. That raises the question, who are these nonprofits and what are the additional rules? Well, these nonprofits are called public benefit corporations. The way an organization is considered a public benefit corporation is in one of 2 ways. Either one, if the organization is a charity, automatically a public benefit corporation. Okay, so not a hard determination, charity, public benefit corporation, great. Okay, and then these additional rules apply. If an organization is not a charity, it may still be a public benefit corporation if last year it received more than $10,000 from public sources. Now, what do I mean by public sources? Either grants or financial assistance from government, and that means federal, provincial, municipal, or an agency of government, or gifts or donations from sources other than members, directors, officers, or employees. The idea here is that the money that's coming in is coming from someone who isn't directly connected to the nonprofit. Either it's government, right, the public par excellence, or it's somebody who isn't a member, they're not a director, they're not an officer, they're not an employee. They don't have any direct legal relationship with the nonprofit. So that means it could be a donor, it could be a foundation, it could be, a company, you know, that's giving money. The idea is also that this money is coming in not in exchange for something. It's not a fee for service. It's a gift or donation. It's a grant or or some form of financial assistance. Okay, so for example, COVID assistance, right? That would have been a form of financial assistance from the government. A grant from a private foundation, right, would be a gift or donation from an organization that is not a member, director, officer, or employee, unless that foundation happens to be a member of the organization. The general idea being captured here is that organizations which receive funds from the public should face some additional accountability. Okay, so what is that additional accountability? What are these rules? So firstly, when an organization closes, when it ceases to exist, what's called dissolving, dissolution, okay? Firstly, it has to pay off everybody it owes money to. Once it's paid everybody off, then the question is, what happens to any remaining property? And when I say property, I'm using the term very broadly. I mean money, I mean real estate, I mean assets, I mean intellectual property, you name it, okay? So the question is, once you've paid everybody off, there's remaining property, who gets it? Well, a nonprofit, generally speaking, can give it to basically anyone, including even the members, and will typically have what's called a dissolution clause in its governing documents. A dissolution clause is a line explaining what will happen to the property if the organization dissolves. Now, it's different for public benefit corporations. ONCA says that public benefit corporations can only give their property upon dissolution to certain types of recipients. So if the public benefit corporation is a charity, then it can only give its property to registered charities with a similar purpose or government, federal, provincial, municipal, or an agency of government. Okay, so charities are limited in who they can give their property to. Public benefit corporations that are not charities can only give their property to, upon dissolution, registered charities with similar purposes, other public benefit corporations with similar purposes, or government, federal, provincial, municipal, or an agency of government. Okay, so those are the new rules around dissolution. The second rule that applies to public benefit corporations is that only up to 1/3 of the directors of a public benefit corporation can be employees. Now, you may say to me, what? Employees can be directors of the nonprofit? You know, isn't that a bad idea? The answer is in many cases, maybe. It may be a bad idea. Certainly for many funders, it will be a red flag. But remember, I'm just highlighting what is possible under the ONCA, not necessarily what makes sense in any given case. Under ONCA, nonprofits in general could have, in theory, their entire board be employees. Public benefit corporations can only have up to 1/3. Now, charities, it's a whole different ballgame. Charity law highly, highly limits the situations in which directors can be employees or paid by the charity in any other capacity. So there is a guide, which I will type its name in the chat, called Paying Directors and Connected Persons. Okay, this guide was put out by the public guardian and trustee, and it explains the limited circumstances under which it's possible for an employee to serve as a director, and the procedure that has to be followed if this is allowed. So I see there's a question, where do public libraries fit into this? There are several of us on the call. Do we qualify? So the answer is, well, if a library is a charity, then it's a public benefit corporation. If a library receives more than $10,000 last year from this source, the listed sources, this year it's a public benefit corporation. And then the same question has to be asked each year to figure out if in this year we're a public benefit corporation. But it doesn't, the definition of public benefit corporation doesn't care about different types of organizations. That's not what it's concerned about. What it's concerned about is whether it's a charity or where it gets its funds. Okay, so thank you for that question, and keep them coming. I will answer them at the end of the section in a pause. Okay, financial review standards. Oh, and I should note the last rule that makes nonprofit public benefit corporations different is they face higher standards of financial review. So what are those standards? So by default, all nonprofits under ONCA need to get an audit each and every year. Okay, that's the default rule. However, many nonprofits have the option of passing what's called an extraordinary resolution and waiving the audit, and instead getting a review engagement or no external financial review at all. So the question is, what's an extraordinary resolution, and who has this option of passing one and not getting an audit? So an extraordinary resolution is a resolution, so it's a motion passed at a members' meeting. But what makes it so extraordinary? It needs at least 80% support at the members' meeting. Now, I want to be clear. This isn't 80% of the total membership of the organization. It isn't even 80% of the members at the meeting. It's 80% of the votes cast at that meeting. Okay, so if somebody leaves the room, or if somebody's not voting, then that isn't necessarily factored into this. It's 80% of the votes cast at the meeting. If you can get that, you can pass an extraordinary resolution, and if you qualify, waive an audit. Now, let's say an organization can't or doesn't want to have a members meeting. Can they still pass an extraordinary resolution? Yes. However, it has to be a written resolution that is unanimously supported by all those entitled to vote on it. All right, so that's an extraordinary resolution. Who can pass an extraordinary resolution, and what's this review engagement that a nonprofit can get instead of an audit? Well, if you look at the table, you'll see whether or not you can pass an extraordinary resolution depends on two things. Number one, are you a public benefit corporation or not? And number two, what is your annual revenue? If you are not a public benefit corporation, then under $500,000 in annual revenue, you can pass an extraordinary resolution, and you don't have to get an audit, you don't have to get a review engagement. Above $500,000, and you have to at least get a review engagement. Okay, so if you're not a public benefit corporation, it's a fairly straightforward rule. If you are a public benefit corporation above $500,000, you have to get an audit. So there's nothing new, nothing has changed for you under ONCA if you are a public benefit corporation with annual revenue above $500,000. If you are a public benefit corporation below $500,000, well, if your annual revenue is between $100,000 and $500,000, you can pass an extraordinary resolution, waive the audit, but you have to at least get a review engagement. If your annual revenue is below $100,000, you can pass an extraordinary resolution, waive the audit, you don't even have to get a review engagement. So this all raises the question, so what's a review engagement? Well, an audit is where a CPA comes in, looks at your source documents like your receipts and invoices, looks at your financial policies like your signing authorities, looks at your financial statements like your balance sheet, your cash flow, etc., and then concludes based on all that whether or not they can provide reasonable assurance that the financial statements are a reliable reflection of your organization's financial position. Okay, that's an audit. A review engagement is faster, it's cheaper because it's not as extensive. It's also a CPA coming in, chartered professional accountant coming in, looking at the source documents, looking at the financial policies, looking at the financial statements, but the conclusion they come to is whether or not they find the financial statements a plausible reflection of your financial position. What that means in practice is that they didn't see anything in their review that looked like a red flag to them. So for organizations with simpler finances that are less concerned about this kind of financial review, it may be a cheaper, more convenient, less intrusive way to do the financial review. For organizations that want the accountability of an audit, where there's more complexity and so on, an audit may be more appropriate. Every organization needs to decide for itself in consultation with appropriate financial counsel. And I am by no means an accountant. Okay, finally, the last big difference between ONCA and Ontario Corporations Act that we'll talk about today. So the Ontario Business Registry is a new online system that came online when ONCA came online, so October 19th, 2021. It allows nonprofits to do all sorts of things online, including filing a notice of change, so informing the government if anyone's changed on the board or if the address has changed. Filing an annual return. So this is the obligatory filing that needs to be made with the Government of Ontario every year, even if it's just to say nobody's changed on the board and our address is the same. And filing articles of amendment. So any changes that are made to the articles, which remember is a synonym for the letters patent. It's the new name for the letters patent. And we'll talk later about when an organization may need or want to file articles of amendment. So these are just a few examples of what can be done online. It has lots more functionality. One of the great things that it allows that, in fact, if you're looking for, what's a good first step for our organization, it allows nonprofits to order a corporate profile. And by ordering a corporate profile, they can check their address and directors on file with the government and make sure that the Government of Ontario has the right information. Why is it so important that the Government of Ontario have the right information about address and directors? Because as we'll see later, for an organization to be able to access the Ontario Business Registry to make changes, it needs to have what's called a company key. And to get a company key, it's going to need to order that company key, and the company key will be sent to the address of the nonprofit. So if the government has the wrong address on file, you're not getting your company key to the right address. Right, so a corporate profile will tell the nonprofit what information does the government have on us. So this can be a good place to start. Now, I want to flag for registered charities that this is not a replacement for the T3010, which is the annual information return of registered charities. So all those filings with the CRA still need to be made. Finally, a warning, there are glitches. There are quite a number of glitches in the system, so watch out. And if you're experiencing glitches, you can reach out to Service Ontario. There have been some capacity issues, so that expect what could be a considerable wait time. And I would also note that you can raise your concerns with the Ontario Bar Association at obrinfo@oba.org, and there's a committee of lawyers and paralegals that are working with the Government of Ontario to improve some of these systems. Okay. So with that, I'll pause, and I see there are lots of questions in the chat, so I'll look in the chat and I'll answer some of these questions. Are you using charity and nonprofit interchangeably? No, I am not. Nonprofit corporations refers to the corporate status of the entity. Okay, so a nonprofit that is incorporated under Ontario Corporations Act, or now under Ontario Not-for-Profit Corporations Act, this nonprofit corporate status means it's subject to this law and the rules we're talking about when it comes to its governance, right? Its board, its members, and so on. A charity or charity status has to do with what that organization's purposes are. Charities can only have exclusively charitable purposes: advancement of education, advancement of religion, relief of poverty, and other purposes which have been found by the courts to be charitable over the years. Furthermore, a registered charity, which is, is a charity that has registered with the Canada Revenue Agency and so has a certain tax status. The tax status is different from the corporate status. The tax status gives it the power to issue tax receipts and also entitles it to certain other tax benefits. So most registered charities are nonprofit corporations for our purposes, right? But not all nonprofits are charities. That's an additional status. So when I mentioned this a bit at the beginning in the disclaimers, when I talk about charities, I'm talking about how a subset of nonprofits face some additional rules because they also have charity status. Can employees be ex officio non-voting directors? So this may be a surprise to some. ONCA says absolutely nothing about the concept of a non-voting director, meaning a director is a director is a director. whether or not they're non-voting is a matter of practice within the organization. But when it comes to the rules of public benefit corporations, meaning only up to a third can be employees, right? Or in the case of charities, it's highly, highly limited when they could be employees. It doesn't matter whether we're talking about a voting director or a non-voting director. The same rules apply. But to address your question, can employees be ex officio directors? The answer is, for nonprofits in general, if the nonprofits bylaws allow for ex officio directors, and they have to explicitly allow for it, the answer is yes. For public benefit corporations, the answer is up to 1/3 of directors can be employees, and those directors may be ex officio or not. And in the case of charities, the answer is under highly, highly limited circumstances, and that organization needs to follow paying directors and connected persons before they allow an employee to be an ex officio director. Thank you for sharing the link. So is the extraordinary resolution a recorded vote? It's recorded in the sense that any resolution needs to be kept in writing. This is true of all resolutions, not just extraordinary resolutions, not just special resolutions. If something is a resolution passed by the members at a members meeting, it forms part of the corporate records. It needs to be kept. Whether the exact vote needs to be kept, so do we need to know that 78 voted in favor and 12 voted against? That depends. So firstly, a nonprofit may set circumstances under which a vote needs to be recorded in its governing documents. So that's one layer of rules for nonprofits to look at. But in general, under ONCA, recording votes works like this. By default, a show of hands is fine, right? You can do it by show of hands. And if the chair of the meeting says the vote is passed, then that is presumed, and that's recorded in the minutes, that's presumed to be evidence that the vote is passed. However, before or after a vote is taken, any member has the right to demand that a ballot be taken. And in such a circumstance, the tally would be recorded, right? Beyond that, it becomes a matter of practice and the decisions of the chair and so on, whether or not there's a need to record the exact vote. But unless there's a rule to the contrary in the bylaws, then a declaration by the chair that a vote is passed is presumed to be evidence that the vote did indeed pass unless someone challenges it. At which meeting is the extraordinary resolution passed? At a members meeting. So that could be an annual general meeting, that could be a special members meeting. My pleasure to Lisa's words. Thank you. Okay, great. Are there any other questions at this time about anything we've talked about? Okay. Not seeing any. Remember, no need to be shy. The questions are a favor to everyone here because if you have them on your mind, likely others do too. So what steps do nonprofits need to take to come into compliance with ONCA? So the first thing is nonprofits will want to figure out, well, does ONCA actually apply to us? So ONCA applies to provincially incorporated nonprofits. That means nonprofits that are incorporated under Ontario Corporations Act or under most special acts. What's a special act? It's an act that was created just for one organization or for a special type of organization. So for example, agricultural and horticultural organizations have their own act. They are also subject to ONCA in addition to that other act. When an organization is subject to an act in addition to ONCA, if there's a conflict between the other act and ONCA, right, ONCA yields, the other act wins. If there's a conflict between a regulation under the other act and ONCA yields, the other regulation wins. So ONCA is designed to be yielding so that nonprofits never need to worry about a conflict. Okay, who doesn't ONCA apply to? Well, if you're federally incorporated, meaning you're incorporated under the Canada Not-for-Profit Corporations Act, you don't need to worry about ONCA. ONCA doesn't apply to you. If you're a co-op incorporated under the Cooperative Corporations Act, then ONCA doesn't apply to you. If you are not incorporated, let's say, for example, you are an old age center under a municipality. You're a program of the municipality. Although you may operate separately, you have no separate legal existence. ONCA in that case would not apply to you, unless, of course, you were interested in becoming incorporated, in which case at that point you may incorporate under ONCA, and then ONCA would apply to you. ONCA does not apply to businesses. It doesn't apply to condos. So those are all examples of who doesn't need to worry about the ONCA. So let's say you figured out, okay, yes, ONCA applies to us. Then you probably want to think about when you need or want to act. So I've already mentioned briefly the timeline. I'm going to go into a bit more detail here. ONCA took effect on October 19th, 2021. And we're in a 3-year transition period that ends on October 19th, 2024. So that raises a question. What happens in this in-between period? What are the rules that apply? Well, the short answer is ONCA applies. However, during this 3-year period, governing documents that were valid before ONCA took effect continue to be valid until October 19th, 2024, even if they conflict with ONCA. So what that means practically is that an organization that wants to figure out, okay, what are the rules that apply to me today, looks in their governing documents, right, assuming those governing documents are valid, looks in the governing documents and can rely on those as their rules. But then let's say a situation comes up and the governing documents are silent. They don't deal with the issue. Well, now they'll be looking to ONCA for an answer, whereas before they would have looked to the Ontario Corporations Act. So at the end of the 3-year transition period, I mentioned that a nonprofit's rules will automatically be considered to transition over to be ONCA compliant. But I also mentioned that there were some exceptions to this. So what are the exceptions? There are a number of types of rules that previously it was quite normal to have them in the bylaws, which ONCA says now need to be put in the articles, right? Now need to be put in the letters patent, which, remember, same thing as articles. If by the end of the 3-year period, by October 19th, 2024, these rules are not moved over to the articles, then that's fine. They continue to be valid. However, if a nonprofit ever wants to make any changes to these rules, those changes would need to be made in the articles to be valid. So what are these rules that need to be moved over to the articles but can stay in the bylaws as long as you don't change them? So number one, the size of the board, the number of directors, right? Number two, if there are multiple types of members, multiple membership classes, and the respective voting rights of the different membership classes. Anything other than one member, one vote needs to be specified in the articles to be valid. But if it says that in the bylaws and it's not moved over to the articles, that's fine as long as no changes are made. And then finally, the dissolution clause. Remember, dissolution clause is that line that many nonprofits will have in their governing documents saying what happens to the property if the nonprofit ever dissolves. So those are some exceptions that last even longer than the 3-year period. But how long does it actually take to transition to the ONCA? So the typical quote that I hear from practitioners that work in this area, from lawyers that work in this area, is 6 to 12 months. It could take longer, it could take shorter. Here are just 4 examples of major variables that might cause the process to take longer for you or shorter. So number one, the age of your governing documents. If you are a long-established organization and you have not looked at your governing documents in a while, chances are there will be more to review, more to change, even beyond the minimum that the ONCA might require. I got in the pre-session survey, I received a question, could you go over the pros and cons of adapting existing bylaws versus rewriting bylaws altogether? Now, the truth is, either could take longer depending on how complicated your situation is. So what are the pros and cons? So the pro of adapting your bylaws rather than starting completely from scratch is that if by and large your bylaws are fine, they've been updated recently, they fit your actual practice, they make sense, you just need to make a few tweaks, then this can be faster, this can be more efficient, and it can be less work, right? The con of adapting your bylaws is if this is a long established organization and these bylaws have been adapted many, many times, they accumulate in complexity, they become increasingly patchwork. There can be all kinds of inconsistencies or misunderstandings about why decisions were made in the past to get to the rules the way they are now. In such a case, it might be simpler and better fit your practice just to start from scratch. And as I'll show at the end of this presentation, our website has a bylaw builder. So you can use that tool to very quickly produce bylaws that are ONCA compliant and also have plain language and clear design elements built in to how the bylaws actually look and feel. But when it comes to rewriting bylaws from scratch, the pro is that you can have a clean slate, you kind of have more control, you understand better why and how all the choices were made within the bylaws. The con is that you may be losing rules that were arrived at for a good reason that you don't understand or grasp why. Additionally, it could be much more work if you are creating a complex set of bylaws from scratch. There can be lots of points of discussion or contention and so on to think through. So that can be more work, and especially if your bylaws by and large are in good shape, that may be more work than necessary. So there are pros and cons to both. I don't just blanketly recommend one or the other. A second variable that might cause the ONCA transition process to take longer or shorter is the capacity of your organization. When was the last time your board read the bylaws? If it was a long time ago, there may be a learning curve, even to get to your current bylaws before you can even think about changes to the bylaws. Are the people involved in your organization, are they generally comfortable with governance issues, with legal issues, or are they more intimidated or anxious? Anxiety can cause, procrastination. It can cause delays. It can make things more difficult to engage in. And by the way, I should note, because I've done dozens and dozens of these workshops, and I always ask in the pre-session survey, how are people feeling? And consistently, somewhere between 20 to 30% of people report either anxiety or feelings of intimidation. So if you're feeling like that, perfectly normal. A large chunk of people feel that way as well. And so dealing with those feelings can be part of this process of getting on top of your governance. Do you have the budget to work with a lawyer? I've heard estimates for ONCA review of somewhere between $1,250 to $2,500 in a typical case. More complex organization, it can be higher. I note that an organization that, for example, uses Clio's tools and does a lot of the work itself, that bill can be much lower as well. You can save a lot of costs. Consensus. If there are major disagreements within the board or between the board and the members or between among the members on some point that is affected by ONCA, let's say, whether or not to have an audit, who should be a member, what the size of the board should be, etc., right? Then it can take longer to build that consensus. That's not necessarily a bad thing. Building consensus leads to more durable rules often, and rules that better reflect and respect all the stakeholders who are actually going to have to live with the rules. However, it can take a while to build that agreement. And then finally, how easy is it for the organization to have members' meetings? As I'll explain in a few slides, changes to bylaws and changes to articles, which might be required for the ONCA transition, requires membership approval. So if it's hard to get the members together, you may be waiting until the next AGM before you can actually approve these changes and make them final. Okay, so let's say you figured out your timeline. Now you want to start doing the work. So what's a good place to start? Getting your books and records in order. This is always a good idea. You don't need to wait for ONCA to know where your records are. Some of these records are necessary as part of the ONCA transition, and some of them are just required records under ONCA. So getting them together, making sure you have them, is itself part of ONCA compliance. So what are some examples of records that an organization might want to get together? So number one, the letters patent and supplementary letters patent. So I've already talked about letters patent, the same document as the articles. If an organization ever made changes to its letters patent, right, and it filed those changes with the government would not send back a new letters patent. What they would send back is what's called a supplementary letters patent. This is like an addendum. So in order for an organization to know what's truly in its governing rules, it needs to read its letters patent and its supplementary letters patent side by side. Not all nonprofits will have supplementary letters patents. Number two, bylaws. Again, you may call them your constitution, you may call them your governing rules. These are the governing documents that contain the rules of governance, things like where to meet, when to meet, what records to keep, whether you'll indemnify directors, things like that will be contained in the bylaws. It's important to know what your rules are, to know what you may need or want to change, and also how to go about changing them. Thirdly, the minute books. So under ONCA, nonprofits are required to keep 4 types of minutes. Number 1, board meetings. Number 2, board committee meetings. Number 3, member meetings. Number 4, member committee meetings. These minutes can be kept virtually. So that's a nice new feature of the ONCA, that it's explicit that things can be kept digitally, they can be kept on the cloud. You don't have to, but it's now an option. I sometimes get the question, can we keep in-camera minutes? The answer is ONCA doesn't say anything about in-camera minutes. When it comes to board minutes, the only people with a right to access board minutes are the directors themselves, so the board itself, the auditor or financial reviewer, or court-appointed officials or other government officials who have the right to conduct inspections and audits. So unless the governing documents of a nonprofit say otherwise, members don't have a right to access the board minutes. Members of the public don't have a right. Donors don't have a right, right? A nonprofit can choose to make those things available, but they are not required to. So in that sense, minutes can be kept in camera according to the policies and governance procedures of the nonprofit. Special resolutions. So I mentioned an extraordinary resolution is 80% or more support. A special resolution is a resolution passed at a members meeting with 2/3 or more support from the votes cast at the members meeting. So if something is a special resolution, chances are it's important. It might be a change to the purposes of the organization. It might be an amalgamation. It might be a major sale of assets, change to the name, what have you, right? So it's important to know what's in the special resolutions because it might affect the rules of the nonprofit. Directors and officers register. Register here is just a fancy name for list. It's a legal term. Lawyers have to make a living too, right? So we come up with these terms. So the list has to go back 6 years and include the names, the start date, the end date, the address for service, meaning the address where the director or the officer agreed to receive official documents from the nonprofit, the email address, if the director or officer agreed to receive documents electronically, and in the case of officer, the title of the officer. Okay, so a list going back 6 years with the current and former directors and officers with all that information I just mentioned. Similarly, nonprofits are required to keep a members list. And similarly, it must go back 6 years, current and former members, their names, their start dates, their end dates, their address for service. So not necessarily their physical address or their residence, the address where they agreed to receive documents, official documents for the nonprofit. Their email address, if they agreed to receive documents electronically, and if there are multiple types of members, what type of member were they? Now, some of you may have heard, and I often get questions, under ONCA, members have the right to access the members list. The reason they have the right to access the members list is because they have the right to get together with other members and do things like demand a members meeting or organize to pass various resolutions, or to collect proxy votes if that's allowed for a nonprofit, etc. Okay, so members have various rights to organize. In order to be able to organize effectively with other members, they need to know who the other members are. So they have the right to access this list. Now, understandably, this gives rise to certain privacy concerns. Firstly, the individual has to sign a statutory declaration, so an official document saying I'm only going to use this information for purposes that are allowed. If they don't, they can be pursued in court and face fines and even jail time. However, if the nonprofit says, we don't feel comfortable even giving this list, or we want to take out certain names or certain details, then it's on the nonprofit to go to the Superior Court of Ontario and explain to the court why this member, who's otherwise entitled to get the list, why they shouldn't get the list or should get a redacted list, right, an edited list. So I see there are some questions, and so I'll come back to this at the end when we discuss questions, because I understand it's a sensitive issue for many nonprofits. Director consent forms. Okay, so when does an individual officially become a director? It's not when they are elected as a director. It is when they consent in writing to be a director. Why? Well, for the simple reason that if all you needed to do to make someone was a director was to elect them, then you could elect anybody, right? As I like to say, you could elect Sean Penn to be a director of your nonprofit, and 4 years later call Sean up and say, haha, you've been liable for everything we've done for 4 years, right? You can't do that, although, it'd be hilarious. For people like me, at least. You need to get their consent in writing. Now, it doesn't need to be a fancy form. I often get asked the question, there's a nomination form. Does that count? They have to sign that. There's a code of conduct that our board signs. Does that count? Does a confidentiality policy count? Do the minutes from the meeting count? So the answer is documents that contain certain essential elements that I'm about to list could count potentially, but if they don't contain the essential elements, it's unlikely that they'll count. So what are the essential elements of the director consent form? 1, the name of the director. 2, the name of the organization that they're agreeing to be a director of. 3, the start date of their directorship. 4, the address of the director, so we know which individual we're talking about here. 5, that they agree to be a director. And 6, their signature. Okay, those are the essential elements. It doesn't need to be a very fancy form. And yes, there's sort of a template that the government has been made available, but it's a template for the first directors of a nonprofit to consent. So if you take out the word first, then it's a consent form for all directors. So that's a template that can be used. It's available through the Ontario Forms repository. Now, the ONCA has said that there will be a prescribed form, meaning that the government at some point is going to issue an official form for director consent. They haven't done that yet. Okay, so but once a form becomes prescribed, then that becomes the form that needs to be used. I'll just note that minutes from the members' meeting will not necessarily count, because those minutes record that the members consented to that individual being a director. They will, unless that those minutes happen to be signed by that director saying that they consent, the minutes will typically not be enough to show consent. And then finally, annual revenue. It's important for a nonprofit to know its annual revenue in order to figure out, do we have to get an audit? If, or can we waive an audit, etc. Are we a public benefit corporation, etc.? Again, I'll reiterate, another important piece of information to gather is the corporate profile. It's not required, but it can be a very useful tool to figure out, does the government have the right address for us on file? One thing I'll note is that under ONCA, the government no longer accepts a PO box as the official address for a nonprofit. We are aware of the disparate effect this has on small nonprofits, on rural nonprofits that have less reliable mail service and so on. It's an issue that CLEO, as well as the ONN, have raised with the Government of Ontario many times. Okay, so we've talked about the basic documents. Now let's review some of the changes that may need to be made or you might want to make to your bylaws. So number one, appointing a chair. Under Ontario's Corporations Act, nonprofits were required to have a president and a secretary. That's no longer required. Nonprofits are still welcome to have those positions and can say so in their governing documents, but they don't need to under ONCA. What is required is having a chair, and the title has to be chair, not chairperson, not chairman, not co-chair, it has to be chair. Why so particular? Because if anything else is entered into the online system will reject it. Now that's IT for you. The chair, unlike other officers, needs to be a member of the board, okay? Only directors can be the chair. Other officers do not need to be directors unless your governing documents say they do. But by default, other officers don't need to be directors. The chair needs to be a director. Number two, ONCA allows corporations to be members of nonprofits. So if a nonprofit wants to allow corporations to be a member, then they need to say so explicitly in their governing documents. So why would a nonprofit want corporations to be members? Well, it could be a fundraising strategy, right? You could have local businesses or whatever as your members. It could be a way to build accountability to other community organizations. So the other community groups are members, so they get to vote at the members meeting and so on, right? It's a way of building mutual accountability. Whatever the reason, and it's not necessarily appropriate for all nonprofits, it's now possible, but it needs to be set out in the bylaws or governing documents. Number three, if an organization has multiple member classes, I mentioned that information now needs to be put in the articles, but what needs to be put in the bylaws are certain details about each member class. Number one, how to join each class of member. Number two, how membership in each class ends. And number three, how to withdraw or transfer between classes. One of the big improvements in ONCA is that it really requires nonprofits to think through their rules more and be much more explicit about them. So this is an example of that. So number four, members now have the right, voting members have the right to demand a members meeting. To do this, they need to get together with other members who collectively control at least 10% of the vote in the organization. Now, a nonprofit can lower this threshold. They can say members who even control 1% can come and demand a members meeting. That's possible. What a nonprofit can't do is increase the threshold. They can't say, no, if you want to demand a members meeting, you have to have 20% or 11%. You can't do that. If an organization wants to lower the threshold, wants to go from 10 to 1%, they need to explicitly spell that out in the bylaws. And finally, by default, under ONCA, proxy voting is not allowed. So what's proxy voting? Proxy voting is where an individual who can't make it to a members meeting or doesn't want to come for whatever reason appoints somebody else and says, this person is going to attend and vote on my behalf. By default, that's not allowed under ONCA. So if a nonprofit wants its members to be able to vote by proxy, they have to allow it explicitly in the bylaws, right, in the governing documents. So what are some things that a nonprofit might want to change or need to change in its articles? So number one, purposes. Nothing in ONCA requires a nonprofit to make changes to the purposes of the organization. However, if a nonprofit has not looked at its articles for many decades, right, and they pull them out and they blow off the dust and they look at the purposes, they may say to themselves, what? These are our purposes? Right? This isn't what we do anymore, right? Or, oh, this language is outdated. That happens. So while a nonprofit is making all these other changes as part of ONCA, it can be a convenient time to also make changes to the purposes. Now note, this is where for registered charities, it's really important to be careful if you're planning on making changes to your purposes to ensure that the purposes you're changing to remain charitable, right? This could affect your charitable status. If they don't remain exclusively charitable, a charity could lose its charitable status. So this is one area where legal advice from somebody who's knowledgeable in charity law could be highly advisable. Okay, number 2, number of directors. So I mentioned that the number of directors, the number of seats on the board needs to be put in the articles. What I didn't mention earlier is that now it is possible to have a range of seats on the board. Previously, that wasn't possible. ONCA allows nonprofits to set out a range of seats on the board in the articles, and then each year, either the members can pass a special resolution saying how many seats they're going to be on the board this year, or the members can empower the board to decide for itself how many seats are going to be on the board each year. Membership classes and voting rights. So as I mentioned earlier, if there are multiple membership classes, this information is expected to be put in the articles, and also the voting rights of those member classes. Now, if the voting rights are just each member gets 1 vote, that's fine. That doesn't need to be spelled out. That's the default rule. But if there's any change to the default rule, let's say one class is not a voting class, they don't have the power to vote, or one class has more than 1 vote per member, right? Each member has 2 votes, let's say, that information needs to be put in the articles to be effective. And then finally, if a nonprofit wants to restrict its powers for any reason, let's say you own a heritage building and you want to say, we're never going to sell this heritage building. To restrict the nonprofit's powers, that needs to be put in the articles to be legally effective. It's not enough to put it in the bylaws. Okay, so very, very quickly, we're going to go over the actual approval process. Disclaimer, the following is the default process under the ONCA. Your governing documents may well set out a different procedure, in which case that's the relevant procedure. The only absolutely essential element of the approval process is that the members have the final say. So a proper members meeting where the members vote is required unless you can pass a unanimous written resolution outside of a members meeting. Okay. Beyond that, the procedure can change and vary based on what it says in your governing documents. So here's the typical process. So somebody proposes the changes to the board. Now, who? ONCA doesn't say. Could be a director, could be a committee, could be a lawyer, could be a volunteer, could be staff. Somebody proposes it to the board. The board then votes. Unless the governing documents say otherwise, a simple majority vote at a board meeting is fine. Now, when it comes to the board approving changes to the bylaws, those changes to the bylaws, unless the board resolution says something different, those changes to the bylaws are effective as of that date. They immediately take effect. But when the board approves changes to bylaws, those changes are only effective until the next members meeting. If the members don't approve those changes at the next members meeting, they cease to have effect. Okay, so once the board has approved changes to the bylaws, and anything the board approves when it comes to changes to the articles are not effective until the government approves them. Okay, so once the board has approved, then it becomes we need to call a members meeting, or wait until a members meeting happens, right? But at some point, members meeting needs to happen. So how do we call a valid members meeting? Well, there needs to be notice. What do you need for valid notice? Firstly, it needs to be sent sufficiently in advance. Under ONCA, sufficiently in advance means between 10 and 50 days in advance of the meeting. A nonprofit may have a specific date or range of dates in its governing documents, in which case that's the relevant timeline. Number 2, sufficient detail needs to be included in the notice to allow the members to form a reasoned opinion about what they're being asked to vote on. How much detail is that? Well, ONCA doesn't say. But one thing I'll tell you is that the last thing you want is to put all this work into changing the rules, get to the meeting, and have the members argue over whether or not they received enough detail, as opposed to the actual substance of what you're asking them to vote on. Number 3, notice needs to be sent individually to members. So governing documents will often provide allowable means to send notice. Could be electronically. We have COVID-19 rules in effect until September 30th, 2023 that allow nonprofits to send things electronically, to send things in person, to send things by mail, however you like. But notice has to be sent individually to the members. It's not enough just to post on Instagram or to post on Facebook, right? Individually to the members. Once valid notice has been sent, then you need quorum at the members meeting. So what's quorum? Quorum is the minimum number of voting members that are required in order to conduct official business at the members meeting. By default, under ONCA, quorum is 50% plus one of all the voting members. Now, you may be shocked. What? 50% plus one? Who gets 50% plus one? We can barely get 10 people to come to the meeting. Yes, that's a common situation. 50% plus one is just the default rule. A nonprofit can set any minimum it wants. It can set an absolute number. It can say we only need 3 people, or we only need 5% of people, right? There are obviously trade-offs. The lower you get, the less accountability, but it becomes easier to hold the meeting. The point here is that quorum is determined in the governing documents, but if the governing documents are silent, then 50% plus one of voting members is quorum. Once the members vote, so you get to the members meeting, the members vote. For ordinary changes to bylaws, it's a 50% plus one vote. It's a simple majority vote by the members, unless your governing documents say otherwise. For changes to articles, it's a 2/3 majority, meaning it's a special resolution, at least. Your governing documents can increase this, but they can't decrease this when it comes to changes to the articles. Once the members have approved, then changes to the bylaws are effective, you're good. They don't need to be filed with the Government of Ontario. Registered charities do need to file the changes to the bylaws with the Canada Revenue Agency. The CRA, the Canada Revenue Agency, does not approve those changes to the bylaws, but they do like to have them on record. So now we come to the final step, filing the Articles of Amendment. So you've made changes to the articles. What you then need to file are Articles of Amendment, literally changes to the articles. There are 3 ways to do this. Number 1, through the Ontario Business Registry. Number 2, by mail. Number 3, through a third party, for-profit private provider. So number 1, the Ontario Business Registry. To access the Ontario Business Registry, a nonprofit needs 3 things: company key, a One Key, and a Service Ontario account. You may already have a One Key and Service Ontario account. This is a kind of username and password type thing. You can create it online if you don't have it. You can use it to access different government services. The company key, by contrast, is specific to the Ontario Business Registry, and you have to order it, which you can do so on the Ontario Business Registry website, and then it gets mailed to your address. Again, this is why it's important to make sure that the government has the right address on file. The second way is by mail. You can go to the Ontario Forms Repository, download the Articles of Amendment form, fill it in, and mail it in. However, here's the catch. Even for mail, you still need a company key. So you still need to go through the process of ordering the company key. Now, you may say, if the government has the wrong address on file, how are we supposed to get the company key? The answer, unfortunately, is that you only have one option. You have to go through a third party. There are 2 third parties, Dye & Durham and ESC Service Corp. They're listed on the Ontario Business Registry website. You go to them, you pay a fee, and they can change your address, by which point you can order the company key. You can also make your other filings, like Articles of Amendment, through these third parties. Some key things to note about the ordering the company key. It can take a little while. Originally, it was 3 to 5 weeks. Now I'm hearing it's more like 1 to 3 weeks. Either way, do be patient. If you order it more than once, the second key is going to cancel the first key. So you're going to get the first key in the mail and it's not going to work and you're going to wonder why. And then 2 weeks later, you're going to get another key and you're going to always, oh, I did this to myself, right? Okay, so that's the long and short of it, probably more the long of it. But with that, I will look at all the questions. And there are legion. All right. What is the ONCA definition of member? So member are those people who have the power to vote for the board. They have the power to appoint the auditor, receive the financial statements, their approval is required for bylaws and so on. Who qualifies as a member will be defined in the governing documents. If they're not defined in the governing documents, by default, They're the founding directors of the nonprofit and anyone appointed by the board. So if you move those items into letters, patent articles, do they also stay in the bylaws? Great question, great point of clarification. So generally speaking, anything that can be put in the articles can also be put in the bylaws. You could have it at more than one place, but the articles trump the bylaws. The advantage of having them in both places, some nonprofits like to do this, is that then you just need to look in the bylaws and you know all your rules. The disadvantage is that if you ever need to make changes, you need to remember to make changes in both places, and it can create a confusing situation if they ever become inconsistent. But from a procedural perspective, moving something from the bylaws to the articles means firstly voting to put it in the articles and also voting to take it out of the bylaws. What kind of expert lawyer consultant would one be looking for to deal with navigating the changes to 48-year-old letters patents? So the Nonprofit Law Ontario website has a directory of lawyers who work with nonprofits. So nonprofit corporate lawyers are the relevant type of lawyer for dealing with letters patent and so on. Depending on, is it a special act corporation, you may need even more of a specialist and so on, but generally speaking, it's nonprofit corporate lawyers. We don't vet or recommend any lawyers, but we do confirm that some part of their practice includes nonprofits, because nonprofits are different than businesses in a number of ways. If deemed a public benefit corporation because government grants and donations exceed 10,000, is the threshold for 100,000 to 500,000 to be based on the total revenue or just the revenue generated from grants or donations? Great question, Scott. It's total revenue. So whenever it comes to deciding whether you need to do an audit or review engagement or what, you're always looking at your total revenue, and it's annual revenue and it's fiscal year, not calendar year. Can you review the exceptions again? Yes, I can. So let's go back. So the exceptions, so remember, these are the things that at the end of the 3-year period, if you haven't moved them over to the articles, they remain valid. So what are they? The size of your board, okay, the number of seats on your board, the number of directors you have, that can remain valid. If you have multiple membership classes, your membership structure doesn't disappear. If the members have different voting rights, their different voting rights don't disappear. It doesn't, change to the default, which is one vote, one member. And any dissolution clause that you have. So any line saying what happens to the property. Now, note, if you're a public benefit corporation, the rules to public benefit corporations apply regardless. The point here is that if you are not a public benefit corporation and you want to have a binding dissolution clause, that needs to be put in the articles. It's not enough just to have it in the bylaws. If the org address is a PO box, what is the correct address? So an organization can list many things as its official address. The official address is essentially, from a legal standpoint, where it's expected to keep its records, where it's going to receive official documents from the government, if the government ever sends official documents. That will also be the address which is listed as its address through the Ontario Business Registry, which members of the public can access. What that address is up to an organization to decide. It could be the personal address of a board member. It could be, a community center where the nonprofit's based. It could be the address of the accountant or the lawyer. So that varies. What if an organization is fully virtual and does not have a physical office address? An office address needs to be given. So as I mentioned, what that address is, there are many workarounds. There are shared spaces in Toronto. We have the Center for Social Innovation. Many people use a lawyer address or an accountant address, but some address needs to be given. And I note that this is the address where the records are expected to be accessible. So you can keep records virtually, and as long as they're accessible from your virtual address, your physical address, then that's fine. They don't need to be physically kept there. Yes, our organization is entirely virtual, as well as our employees don't feel comfortable listing their home address. For sure. So as I mentioned, there are a number of workarounds. Do the articles and bylaws have to be consistent regarding member responsibilities, e.g. fees? So the information about membership fees do not need to be included in the articles. They can, You don't need to. And they can be included in the bylaws, but they don't have to. The default is, if nothing is said about membership fees, the board has the power to change membership fees. Most of the people in St. Mary's have a PO box. Yep, as I mentioned, this is not a kind of equitable rule. It affects different organizations quite differently. Are we able to receive or access the CLEO PowerPoint presentation? Yep, absolutely. I will send this document around. Can inclusion in the org's minutes with that info count? So I believe this is the director consent. And as I mentioned, if it includes all the essential elements and they've signed and so on, in theory, any document could count, but typically speaking, the minutes record that the members approved, not necessarily that the director consented. What is the annual revenue bullet point? It's important for nonprofits to know their annual revenue to figure out, can we waive the audit? Are we a public benefit corporation and so on? What happens if you don't have a physical address though? Our office is the home of the secretary, which changes every 3 years. As I mentioned, some address needs to be listed. There are various ways to create consistency, or it may simply mean that every 3 years, the nonprofit has to file a notice of change indicating that the address has been changed. Can you have more than one chair? So the answer is yes. From a practical standpoint, a nonprofit can organize its governance and its officers however it likes. But for the purposes of filing with the Ontario Business Registry or with the government, somebody has to have the title of chair. So practically speaking, there could be a chair and a co-chair, and they could have the exact same job. ONCA doesn't say what the job description has to be, but somebody has to have the title of chair. Charities are not allowed to have a PO box address. Can you have a fixed address used to satisfy ONCA, but use a PO box as a mailing address? So the fixed address that's given to the Government of Ontario is the address that the Government of Ontario is going to use to communicate with it. The nonprofit, in its dealings with other individuals, with other nonprofits, with other businesses, is welcome to use whatever mailing address it likes, subject to the rules of any contract and so on. Thank you for putting the survey there. Under ONCA, are you permitted to elect directors at a separate meeting from the AGM? Thank you. And in fact, this was one of the questions in the pre-session survey, so I'm glad somebody brought it up again. So the answer is yes, directors can be elected at any members meeting. It doesn't necessarily have to be the AGM, and an organization can put in its governing documents what its election procedures are going to be. But by default, these elections do happen at the annual members meeting. Can you please clarify the requirement to notify individual members? Is a group email to all members sufficient? Yes, a group email is sufficient, especially under the COVID-19 rules where electronic notice is allowed. The idea of individual notice just means that they need to receive it individually. So a group email, each individual received it individually. What isn't allowed is posting something, let's say on a bulletin board and say, oh, it's up, anybody could walk by and see it. That's not individual notice. Or an e-blast in the sense of we posted it on Instagram and you're all members of the Facebook group. That's not individual notice, right? How long do minutes have to be kept? Okay, so strap in, right? All of the minutes need to be kept forever. Now, practically speaking, most nonprofits can't do it. Right. And if you can't do it, you can't do it. Right. That's the practical reality. And from a risk perspective, the thing a nonprofit will want to consider is, will we ever need to rely on these records going forward? Like, what's the likelihood we're going to be sued or challenged? And we will want to be able to point to our minutes and say we did our due diligence or whatever. That's the kind of risk assessment a lawyer would do. But practically speaking, whether it's worth the money or time, or whether it's even possible to reconstruct those minutes, as I mentioned, there are no ONCA police. If our director consent forms did not include all the information now required, do we need to go back 6 years and get previous board members to sign a new consent form, even if they are no longer part of the board? So this raises an interesting question, which is when does this requirement actually kick in? And the answer is under ONCA, the rule kicked in only as of October 19th, 2021. So the 6-year requirement is just for keeping the records. It's not for the consent form. Those are separate requirements. And as far as what is the effect of not having adequate consent? So I'll tell you, there's the law, there's ONCA, the legislation, and then there's the common law, which is court decisions. And ONCA says for a director to be a director, you need to consent. However, if somebody acts as a director, right, and let's say they sign agreements, they pass resolutions and so on, their acts are not going to be invalid just because they didn't sign an agreement. And the common law goes even further. The common law says if it looks like a duck and it quacks like a duck, it's a duck. Meaning if an individual acts like a director and makes all the decisions of a director and so on, they're not going to, it's unlikely that they're going to be able to go to court and say, oh, but I didn't sign the form, right? And then somehow escape liability. So that's an important kind of practical context. But from like strictly legally speaking, ONCA requires director consent forms to be kept with that kind of essential information for directors, at least starting on October 19th, 2021. What if we didn't have director consent forms at all? So the sort of what I just mentioned, from a practical point of view, if something ever went to court, courts are quite pragmatic, and ONCA says it doesn't cause any decision to be legally invalid. So I'm not seeing any more questions in the chat. So I will just go to the final slide, which is feel free to reach out to me, benjamin.miller@cleo.on.ca. If you have questions, I can provide legal information, not legal advice. I'm sorry I didn't have time to give you a tour of the website, but this is the website. There's a bylaw builder, there's a guide for reviewing your bylaws, there's more information on all the topics we discussed. So I thank everyone here for your great questions, and I thank the United Way so much for having me.